I'm Michelle Smart. I'm an enrolled agent. I'm trying to keep you updated on the latest on the employee retention tax credit. So, as you know, I have advised people to continue to stay in the game of the ERC because some of these lawsuits are being played out and some of the rules may be changing. And as you know already, the Stenson Tamidon lawsuit, which I've talked about in previous videos, has made a significant change in that the IRS had to backstep on relying very heavily on their notice 2021-20, for which many of you have relied in order to qualify for partial suspension or qualify in other ways for the employee retention tax credit. So there has been another lawsuit that was filed on May the 5th. So if you are borderline, whether or not you qualify for the ERC according to 2021-20, I would stay in the game, because here is another lawsuit, which is basically saying that they are asking the courts to throw out the 2021-20 because it was illegally enforced. So let's first of all take a look at what all is in 2021-20, the notice that was publicized by the IRS. So remember that in order to make something a law, the IRS must post, take questions, and so forth in order to have something be a particular guideline. There are certain processes and procedures that they have to go through. And on 2021-20, they did not go through those procedures. So historically, what happened now is there was the Denson-Tamidon lawsuit, which challenged this notice 2021-20. And when there was a response to that lawsuit from the IRS, they admitted that this is not a hard and fast law, which they had to admit. And now this next lawsuit is saying this should be thrown out in its entirety. All right. Here are some of the things that are discussed and outlined in this notice. So these are the things that this newest lawsuit, which came out May 5th, 2025, is challenging. Who's an eligible employer? The aggregation rule, governmental orders and partial suspension, the significant decline in gross receipts. Some of you are right on the border, maybe you have a 19% reduction in gross receipts. What's qualified wages? All of these things listed here are in 2021-20. So if this lawsuit succeeds, it's going to be very difficult for the IRS to challenge anyone who applies for the employee retention tax credit. This is why I keep saying, wait till these lawsuits go through the court system before you decide, oh, I didn't really qualify. I'm not sure. I'm afraid. Now, here's this lawsuit and I will leave a link to this so you can download it. This is First Source Employee Management, Inc. versus the IRS. And they're basically saying that they should throw out 2021-20. Okay, here's what I want to show you right here, what it's asking. And it's saying that plaintiff asks the court to enjoin United States Internal Revenue Service nationwide from enforcing or otherwise relying upon IRS Notice 2021-20, which consists of guidance materials in reviewing ERC claims, and to vacate IRS Notice 2021-20. I won't go into all of the detail here. You can read this case if you would like to read it, but this is really, really interesting. I would say hang in there. Don't give up on the ERC if you think you're in a gray area, or if you've received a disallowance notice. Just tiptoe through it until some of these cases come out. If you don't have the money to file these cases, just watch other people who are doing it. If you just give up and walk away, then you don't have a chance as these cases play out. So even though it's too late to file for ERC at this point, if you have it filed already, just hang in there to see how these things are ruled upon. because it may be that the IRS cannot challenge your claim at all if they've got to throw out Notice 2021-20. So I'll leave a link for both of these things, to this court case and Notice 2021-20. And as usual, please like and subscribe so other people who are looking for this content can find it. Thanks again. I'm Michelle Smart. I'm an enrolled agent trying to keep you updated on the latest on the Employee Retention Tax Credit.